Hey, everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh, and I have not brushed my hair. So we have a new letter to the judge from Stephanie Jones and JonesWorks attorneys, and this is regarding all that was going on with Edgeworth Security at the end of last week. If you missed that, Wayfarer parties and Justin Baldoni have tried to subpoena records and communications from Edgeworth Security, who were hired by Stephanie Jones when they terminated Jennifer Abel. Jennifer Abel alleges that their security staff kind of pressured her and kept her in that room, basically, against her will. That's the allegation, at least. And their technicians extracted all the forensic data off of her laptop and the company-issued phone. Now, they told her that they were doing this for the purposes of they required that for some reason to release her personal phone number, which she had since she was in high school, and she could then attach it to a new phone that was not owned by the company because she was going off to start on her own. Then what happened from there is Blake Lively filed the Vanzan lawsuit, the John Doe lawsuit, and then obtained those communications that were extracted off the devices directly from Stephanie Jones without ever notifying Jennifer Abel or any of the Wayfarer parties. The sketchy part about that is obviously being that they used this shell company to get around any means of notification. So nobody had a chance to object to that or to fight it and say, like, no, you don't have a right to get these communications. And then, of course, Stephanie Jones just handed them over and said, I have nothing to hide, which is rich because now when Edgeworth Security is being subpoenaed, she's like, no, you can't do that. So obviously you, one, know what a valid subpoena looks like, and two, know how to fight it. So then the Wayfarer parties were arguing to the judge at the end of last week that the crime fraud exception should come into play because Stephanie Jones is saying that these communications with Edgeworth should be privileged. And then we're going to see what Stephanie Jones attorneys here are saying in response, because that letter was filed late Friday night. So this is still an ongoing issue. One sec. This is not very long, guys. I got to get back to work, so it's good that it's not. Okay. Dear Judge, pursuant to Rule 4C of this court's individual practices, JonesWorks LLC respectfully requests leave of this court to file a letter of no more than 3 pages in reply to the Wayfarer party's opposition to JonesWorks' motion for a protective order. A mere 2 hours after JonesWorks filed its letter motion for a protective order to prohibit enforcement of a subpoena served on a third party, Edgeworth Security Services LLC, that plainly seeks JonesWorks privileged documents, the Wayfarer parties filed a 3-page letter motion seeking to invoke the crime fraud exception to overcome that privilege. During multiple conferrals over the course of more than a month, the Wayfarer parties did not once mention the crime fraud exception as a possible basis for overcoming JonesWorks' well-founded assertion of privilege. This is for good reason. The exception is wholly inapt. The Wayfarer parties flouting the court's conferral requirement and hiding their intent reveal... You're joking, right? Not you talking about hiding your intent. Ooh, okay. Their intent reveal that the pre-baked opposition to JonesWorks' motion is without merit or good faith basis, and instead appears primarily designed to further their outlandish media narrative against JonesWorks. Okay. Further, because the Wayfarer parties concealed their intent to raise the crime fraud exception in relation to this subpoena and failed to raise it on any conferral, JonesWorks, of course, has had no opportunity to address the issue and its inapplicability to the present situation. This type of sandbagging and litigation by ambush is precisely the type of conduct that this court has recognized warrants permitting a reply. Okay. The footnote here says the timing of this filing alone reveals that the Wayfarer parties have been lying in wait to file this motion. I'm sorry, this is the most hypocritical piece of... All right. Have been lying in wait to file this motion, as does the reference in their letter to false imprisonment, which was one of the 6 claims Jennifer Abel abandoned in her most recent amended counterclaims in the related case and is, at this time, no longer pursuing. JonesWorks' expected reply will include arguments that 1, the facts stated in the Wayfarer party's response are flatly false, and they and their counsel knew they were false when asserting them to this court. 2, the Wayfarer party's invocation of the crime fraud exception is patently frivolous, including because they fail to present even one iota of evidence to substantiate their false assertions, despite acknowledging that they must do just that to support application of the exception. And 3, the Wayfarer parties are abusing this court's docket for extrajudicial purposes, including to launder defamatory statements about JonesWorks through documents ostensibly protected by the litigation privilege. JonesWorks thus respectfully requests that this court grant it leave to file a letter reply to assist in this court's resolution of the instant motion. Okay, then. So I don't know, like I always say, I don't know how this is going to play out in court, but just from a layperson's perspective, you're sitting here whining about the same exact things that you did to these other people. If what she's saying is even actually an accurate characterization of this situation, which I don't know that it is. So, yeah. Them fighting so hard to keep the security firm out of this is highly suspect. I mean, it's pretty obvious what's going on here. Like I said, I don't know how it's going to play out in the court, but it's pretty fucking obvious what's going on. Like I said, I do have to get back to work. So sorry this was a short one, but thank you for watching, and I'll see you guys soon.